be not controlled by any patent holder. They can use those sequences in a patent, but then that sequence is still open for anyone to use for further invention, innovation, competition, which in medicine is so important for controlling costs, for getting better therapies, better diagnostic tests. That's what I'm asking for.
Mr. Lee, when I was a kid, people were scared to death of polio. We have a colleague who's now suffering from some long-term issues he's had with polio, and many of us knew personal stories. Along comes Jonas Salk with a vaccine. I didn't care for the shot in the arm, but my mom was finally relieved, and I realized later how important it was in my life. Dr. Salk said at the end of the day, I'm not going to patent this vaccine. I want everybody to have it. I think it's important for public health. When I listen to Dr. Leonard, I hear her saying my research is going to be restricted by the patent rights others are claiming. Do you feel the same?
That certainly can occur depending on how the patent is scoped and depending on how you look at Section 101. Obviously, there's some views that the aperture should be increased. We've heard that. And what that would do is allow more patents on things that the Supreme Court has said are basic fundamental building blocks of research and innovation. The laws of nature, mathematical relationships that exist, these are things that are part of the storehouse of knowledge for all men, is what the Supreme Court has said. And because of that, those things have been restricted from patenting by the Supreme Court's Section 101 law. If that is changed and more of that material is allowed to be patented and thus owned exclusively by one patent owner, then it's going to be much harder to use those building blocks for further innovation.
Are you agreeing with Dr. Leonard?
I am agreeing with Dr. Leonard.
So you're opposed to the bill that's pending as written?
I think PURA has its issues and certainly could use some refinement to make sure that some of these dangers don't happen.
Thank you, Mr. Chairman.
Senator Durbin, could I clarify?
Sure.
I am not talking about research. I am talking about medical care for patients.
I see. Thank you.
Senator Blackburn.
Thank you, Mr. Chairman, and thank you to each of you. When I talk with Tennesseans, they want to make certain that we stay on the cutting edge when it comes to medical innovation and utilization of healthcare technologies. And Dr. Leonard, as you were just mentioning, talking about patient care and making certain that that care is available to Tennesseans. Director, let me come to you, and thank you for the work that you were doing. We had looked at a State Department study. China is now leading the U.S. in 57 of 64 critical and emerging technologies. Does that compute with what you hear?
Yes, indeed.
And in this, they're also leading in AI. Is that accurate?
My personal understanding is that with respect to AI is a very broad field. Many different technologies within it. They are leading in many of them, and they're neck and neck with us in others. And I believe that if we don't do something about our patent system here in the United States, we will eventually lose that race.
Well, Senator Welch and I have been on this issue of protecting intellectual property and making certain that we rein in the virtual space. We've been working on that since we were each over in the House. And we have legislation, the Leadership in Critical and Emerging Technologies Act, which would expedite patent exams for AI, semiconductor, quantum computing. So you've just touched on this. How would resolving this uncertainty that really surrounds these emerging technologies and the patent system, how would that strengthen our ability for keeping that innovation U.S.-based?
Yeah, thank you, Senator. Great question here and a bunch of issues. First of all, for the United States as a free market economy to maximize its innovation output, it needs reliable intellectual property laws that apply in a predictable way to the entire scope of technology. Right now, there are major areas of technology that are basically not eligible for patent, okay? Medical diagnostics we've discussed, but a lot of information-based technologies. And we live in the information age. And courts took upon themselves to effectively exclude from the patent system the technological processing of massive amounts of data in innovative ways. That's another example. Without that, we will have some innovation here, and we do. And there is investment in innovation, some of it, and we do have that. But if we want for the United States to maximize its potential, the only way to do that reliably in a free market economy is through intellectual property laws, which our founders understood from the very beginning. And without that, we already have fallen behind China, as you have indicated, Senator, but imminently, we will fall far behind, and it will be very difficult to catch up for the rest of the century.
Let me ask you this, just following on to this and para, Section 101 of the Patent Act, the Supreme Court has refused to revisit that. Why do you think para is the appropriate solution to bring some clarity, some continuity, and some confidence to that issue?
Because only Congress can do that through statute. The Constitution empowers Congress to define the patent laws, and Section 101, for all practical purposes, was written in 1793. The 4 categories of patentability were written when Jefferson and Madison were writing laws in 1793. Congress has not changed the categories of patentability effectively since then, and courts are having a difficult time figuring out how to apply an 18th century statute to 21st century law. And I just want to emphasize how important this is for the United States. Yes, we will have a Dr. Salk every now and then inventing unbelievable technologies and dedicating that to the public. And people can choose to do that as they wish. But for the United States, if we want investment and innovation at scale, they can compete with a very determined China and others, we need reliable intellectual property laws. And para does that.
Yes. And do you agree that denying patent protection for AI innovations effectively forfeits American excellence and leadership to our competitors?
I very much do that, and more than that, Senator, what it does is, in addition to that, it concentrates technology in the big and established